event. So let's commence.
Samya?
Yes, ma'am.
Who has to start?
I would like to invite dignified Dr. Sugandha Goel, ma'am, Dean Academics, to give her insightful address.
Good morning, all. I'm sorry that I was not able to connect it immediately. There were some technical issues. Good morning, and I welcome Mr. Colonel A.K. Vashish, sir, who has taken our request to join with us for this moot court activity. My dear young friends, mooting is very important part in your legal education. While much stress is laid on educationists and neurologists, but we hear little about the importance of being articulate. Yes, we have seen so many times. When I was young and I was learning, I have seen that most of the person are looking for taking admission in law courses. But everybody is not becoming a good lawyer or a successful lawyer just because of the reason they has no knowledge of practical knowledge how to tackle the court, how to stand in the court. I think moot court was introduced for this purpose only. We people are doing this activity regularly in our college. What I found that students are much more comfortable when they are going out after completion of their course. If they have participated in these kind of the activities in the campus or the institute, and this shows us how to stand, what is the postural, what is the language, how to give the information to the judge or the person in a effective manner. Moot court activities, I think so that it is a part of your core curriculum activities, but it is an important activity. We have been organizing this activity for for national level from last 2-3 years. And this is the second moot court activity. I think this is in third, I remember, sure, this is in third activity or second or third, whatever. I appreciate the participants who have taken the part, who are looking after to take part in this activity and competing others. This might, and as always, when there are number of teams, there is only a one winner, but this doesn't mean that others are the losers. Others are also the gainers, but they don't have trophy in their hand. But they have a knowledge. They have gained vast knowledge according in these kind of activities when they are competing, large number of these groups. And I hope you all will learn from this activity from IPM. Wish you very best of luck. And I will be the person who would like to attend these kinds of the more activities as and when. Good luck and thank you for being a part of IPM activity. Thanks a lot.
Thank you, ma'am, for your encouraging words.
Okay.
Moving on, I would now like to invite Dr. Neelam Singh, ma'am, HOD, IPM Law Academy, to deliver her words of wisdom.
Thank you, Dania. A very warm good morning to all present here. I welcome all of you on the very first day of our second BS National Virtual Moot Court Competition 2021. First of all, I welcome our today's guest, Colonel Dr. A.K. Vashishtha sir, for sparing the time from his busy schedule. I know he has a very hectic schedule, so I want to thank you that you accepted our invitation on a very short period. I welcome our judges of the whole event who are the legal libraries of different legal fields. I welcome our secretary, Mr. Anupam Goel sir, our Dean Academy, Dr. Sugandha Goel ma'am, our Director General, Colonel A.K. Gill, sir, I welcome all the participants of the various colleges from all over India. I welcome our faculty members and student coordinators. We all know that no event can be conducted spontaneously so as to law events. Every event needs a lot of preparation, hard work, coordination, starting from the invitation to conduction of the event. So the National Virtual Moot Court Competition also consumed the same. I mean the core hard work of the organizing team from the last 4 months especially. Every legal person knows about the moot court because moot court is a very important activity in the field of law. As ma'am has already explained the importance of the moot court, so I'm not going into it because we all know the importance and that's why we all are here to participate or to organize this activity. I pray to the God for successful completion of the event. I wish all the best to all the moot court teams for the competition. As a customary practice, there will be only one winner, but believe me, whoever put a lot of hard work to reach at this point and participating with full confidence and knowledge to this competition is the winner. Champions are not made in the gym. Champions are made from something they have deep inside them, a desire, a dream, a vision. Thank you so much, organizing team, for giving me chance to welcome the audience and the guests. Once again, I heartily welcome you all. Thank you so much. Over to you, Daria.
Thank you, ma'am. That was indeed motivating.
गलत तो नहीं किया ना एक दूसरे को और मेरी डिटेल्स है ना आप पे बैंक की कि आपने पे मंगा लोगे
It's time to call our eminent speaker for today, Colonel Dr. A.K. Vashishta. He was Department of Army from Officers Training School, Madras, 4 September 1987. He is Special Public Prosecutor for Courts Martial. He is a columnist on India-China strategic relations in Times of India, Economic Times, OP India, and Counterview post-Galwan episode. Peer reviewer for commentaries on Geneva Convention 4, composing Vishnu Sahasranam, and please welcome Colonel Dr. A.K. Vashisht. I request Colonel Dr. A.K. Vashisht to please join us.
Sir, kindly unmute.
Yes, can you hear me, please? Am I audible to everyone?
Yes, sir.
Thank you so very much. I'm very grateful to you for having given me this honor. I've just heard my biodata, right? A very brief biodata of mine. I wish you had made a little mention about my stint with the Maharshi Law School as a dean of a law school there, where I had the great honor of, great privilege of working with your present HOD and Dean, Dr. Neelam Singh, because of whom I am here on this platform today. Well, I'll make a little more introduction of mine during the course of my keynote address. Uh, Respected Dr. Sugandha, Dr. Seem, the faculty members of the IPEM Law Academy, the management, the organizers of this function, and the teams which are participating in this prestigious second All India Moot Court competition. I have gone through your memorials, though there was a little paucity of to go through it and understand it. I find it is very interesting and of course very challenging. I'll be covering it, I'll be just touching upon it. Certain important points of 136 special leave petition which you have preferred and on which you're going to argue. The teams are going to present themselves. But before that, I would like to share a few words of experience with you. You addressed me as Colonel A.K. Vashishta, but I must share it with you that I come from the Department of the Judge Advocate General of the Indian Army. We are known as the military judges, and we sit in the court martials and we try the accused persons of the army. And the court martials that we have, the four kinds of court martial: the general court martial, the summary general court martial, the district court martial, and the summary court martial. The general court martial has the power of award the sentence of death. So we actually function, most of the time we function equivalent to the appointment of an additional district or a district and sessions judge, because the court martial which we preside over, or which we become as the legal head of that court martial, we have the power to administer justice in accordance with the Army Act rules, the right laws, Constitution of India, everything, and also resort to the award of punishment if the accused is found guilty, even to the extent of death. So that's about the military experience of a military judge. I have held this appointment for almost about 32 years, in which for about 25 years I have done as a military judge, and the other 7 years I was an instructor, I was chief instructor at the Institute of Military Law, where we trained the Army, Navy, and Air Force officers of India and abroad, and of other countries also. Now, coming to the present subject and the present, I must also share it with you, ladies and gentlemen, that at the moment I am addressing you from the Union Territory of Jammu and sitting very close to the Indo-Pakistan border. It's just rather very interesting that your head of department, Dr. Seem, has been able to dig me out, to search me out of this place and engage me on this prestigious assignment. To the my words of experience are to be shared with the teams which are participating. I'm very glad to know that there are 19 teams participating in this moot court competition. I from myself, when I started my law in the year 1982 in the university at Shimla, Himachal Pradesh, 1982 was the time when I joined. The moot court, the concept of moot courts was just evolving. It was just coming up. And we were the early subscribers to the concept of moot courts. Just a few batches before us, that the system of holding moot courts in the law faculties had started. And since then it has evolved over and over, to the extent that when we hold the All India Moot Court competition, we send even the candidates abroad. I remember that in 1983, when I represented my university as the Banaras Hindu University All India Moot Court competition, most of you have heard the name of the venerable, the very respectful Dr. N.R. Madhava Menon, who is the founder of the first National Law School, India University, NLSIU, in Bangalore. That was the first one in India. Today we call it the Harvard of India. He was the one who presided over that moot court competition. He came on our the last moot court competition, and he presided over the valedictory function of that moot court competition in 1983 in Banaras Hindu University. At that time, he was the secretary of the Bar Council of India. And the National Law School India University had not yet been established. It was just an idea probably in his mind. But when he came and he presided over the function, and there were teams participating from all over, and I might share a few words with you that you have heard the name of Shri Mohan Parasaran and Shri Gopal Subramaniam, who have been the Solicitor General of India. You'll be glad to know that they were the part of the participating team. They were representing Delhi University in that competition, and I was representing my university along with another candidate from my university. Both of them, they rose to become the Solicitor General of India. So that's the time when we actually realized that what is the importance of a moot court. I came from a smaller place. Himachal Pradesh was a smaller state, and the university, though a very beautiful and a very good university, but still, as compared to Delhi, Bombay, Kolkata, or other places, this was still a smaller university with lesser exposure. Punjab University was a very big university at the time. So when I saw this platform, I found that how much is there for people coming from smaller places to learn. And I saw the level of knowledge which was being shared by the teams. It is not that there's one problem which is given to all of us to argue before the bench. As a matter of fact, it is an exchange of a concept. It is an evolution of a concept of learning. Learning on a platform which is away from the books. Whatever we have learned by way of research, by way of structural, tailor-made study, by way of reading books, hearing the lectures of our respected and venerable professors, teachers, lawyers, judges. How do you put it into practice? When I was in the army, you would have heard a very, very popular adage which we use. I used to say, I am an officer and a gentleman. When I joined this profession, I resigned from the post of a dean to become a lawyer. So I'm sure this part of my experience is that I resigned the post of dean to become a lawyer. Would give you some inspiration that how important, and if you have a passion for law, how it can pull you out of any place. It pulls you out of the place of comfort. That passion doesn't let you rest in a comfortable environment. You can relinquish everything for the sake of your passion. Buddha, he relinquished kingdom. He relinquished all the princely pleasures to find out what the truth is, because he had the passion to find out truth. Similarly, when you become a lawyer, you have a passion to pursue a particular way of life. And law is not profession. It's a way of life. You read law. You speak law. You even eat and drink law. You talk of nothing else except law. It's the law which governs us. We have very simple concept. We just know when a child is born, he cries. Have you ever heard a child smiling or laughing when he is born? No, it's the law of the nature. Because when a child is born, if he doesn't cry, his lungs will not expand. That's the first breath of air that he gets. And for that, what is important is crying. That's the law of nature. The sun rises in the east and sets in the west. Is the law of the nature. A person, we have the great book, the Bhagavad Gita. Dehinas minyatha dehe kumaram yavram jara tata dehantar prapte dhirastatranam huyata. You're born, you become a child, you become an adolescent, you become young. Similarly, you become old and then you pass away. That's the law of nature. Aging is the law of nature. So what is important? What is the, in Sabka Sutra kya hai? What is the thread which is connecting all these beads together is the law. And law is not confined only to books. Law is all over. Only little parts of law are encased in books. It's like water. It's like air. Air, oxygen is contained in a small cylinder. It's everywhere. Similarly, law is everywhere. The codes, it's codified in certain acts in the form of books. So whenever we say that we are talking about law, whenever we say, so as I told you that when I said that I was an officer and a gentleman, today I say I'm a lawyer and a gentleman. Or either way, I'm a gentleman and a lawyer. Similarly, for the female gender, I'm a lady and a lawyer. That's how it goes together. A lawyer has to be a gentleman. A lawyer has to be a lady of the first class. The lawyer, that is why it's spelled as L-A-W-Y-E-R and not as L-A-I-R. It doesn't rest on lies. Whatever a lawyer speaks is truth. The highest propagator of truth is a lawyer, because whatever he says, he wants the court to believe that whatever he says is true, is correct and right. If he says the sun rises in the west and not in the east, he will have some reason to say this. So that is the level of wisdom that a lawyer has in his mind, in his head. Now coming to the problem specific, coming to the case which you're going to argue before the benches here during the Moot competition. I shall not discuss the details of this case. I shall only briefly touch upon the provisions of the Constitution of India, which would actually be reflected there. We are all aware, being the students of law, that whenever we talk about the criminal jurisdiction, our mind, before we come into the Constitution of India, it goes to CRPC. Section 6 of the Code of Criminal Procedure says the highest court, we know that law and order is a state subject. We have a unitary federal structure, we have independent states. Whatever is available in the union, in the center, we have a parliament and the rest of the things. We have replicated the same model in every state, all over India. So we are a union of states. We have put independent units together with a strong unitary bind over there, connection over there. But law and order has been left to the specific states. Whenever it comes to the criminal law is a state subject. That is why the parliament has allowed every state to have its own amendments in the CRPC. We are all aware of that. When it is a state subject, then which court should be the highest court of criminal jurisdiction? It should be the High Court, and that is how it is. When we take a look at Section 6 of the CRPC, we find it says besides the High Court, it starts with the High Court. It doesn't talk about the Supreme Court, because Supreme Court is an apex court. Supreme Court in itself houses the criminal jurisdiction, the appellate jurisdiction, the civil jurisdiction, the original jurisdiction, etc., etc. 141, the law that is declared by the Supreme Court is binding on all the courts. It's like the Gangotri, from where the holy Ganges comes and spreads all over the Gangetic plain and covers every court and tribunal within the territory of India. So the highest court of criminal jurisdiction, when we talk about the criminal law, is the High Court. And then Section 6 goes on to explain which all courts we have other than the High Court. You have the district, the sessions courts. Then you have the magistrate of first class, the second class, and executive magistrate. So whenever there is a criminal matter which needs the attention or which needs adjudication by the Supreme Court, it has to meet certain conditions. It's not a case under Article 32 that you can approach the Supreme Court right away. It has to follow a particular rule. It comes from the lower court of the district or the sessions district and sessions judge. In the sessions division, it comes, and from the sessions division, it comes to the High Court in a criminal division, and from the High Court, it goes to the Supreme Court on certain conditions, and for that we have Article 134. Right? You would see that in case of criminal cases, there is also a special provision where the High Court can give a certificate on verbal, on an oral or a written request made to the High Court, where an important question of law is involved, or where a finding of not guilty in a case of murder, or where the sentence is death has been converted to guilty by the High Court, and a sentence of death has been awarded. We are leaving the criminal jurisdiction of the Supreme Court aside, where Supreme Court on its own suo motu can take notice of certain matters which are pending before the High Court, or any court for that matter, because orders of the Supreme Court are applicable with respect to this criminal and civil jurisdiction, at least to the first two tiers of the judicial structure. And the first two tiers are the Supreme Court, the first tier is the High Court, and the second tier is the courts of the subordinate jurisdiction, the district court downwards. Here we have a matter before us under Article 136. 136 is a provision which deals with the special petitions. Sushil answered that. But I'll not go to this specific again, because I would like you people to research and present it before us when we see how well you are doing. I know you all be doing very well, very well, much better than my own expectations of you, because you are hardworking lot. But remember a few things with respect to this. In case of the special petition, you must note one thing. Whenever you read a judgment delivered by the Supreme Court by virtue of OSL, you would notice one expression, leave granted, and then starts the rest of the judgment. What does it signify to a lawyer, to an advocate, young advocate, or to me, or to anyone who's in the field of law? It signifies that first we have to make out a case that the Supreme Court grants us the leave to petition, grants us the leave of audience, first grants us the leave to listen to whatever we want to place before it for adjudication. So, ladies and gentlemen, as good lawyers, you must first of all, if you are arguing a matter before the Supreme Court, must first make out a case that the leave ought to be granted to you on the basis of your arguments and based on the merits of the case. And how much time is generally granted by the Supreme Court? A few minutes, starting from a few seconds to a few minutes. And those are precious moments in which you have to crystallize your whole paper book. You understand what is a paper book? Paper book are the pleadings which are presented before the Supreme Court. Those may run into thousands of pages, hundreds of pages, but you have to crystallize the issues which are emerging out of that paper book in just a few seconds or maybe a minute and a half. So there's a time when the Supreme Court grants leave and places your case into the regular list for hearing. So whenever you make your argument in this particular case, which is a criminal matter, you must keep that fact in mind, that you have come before the Supreme Court in SL, and you have to make out a case by yourself. There is no certificate from the High Court to back up your case. It's the strength of your argument which has to convince the court that yes, leave should be granted and your matter should be heard. Of course, it's a moot court competition. You have to argue your matter till the conclusion, till the concluding argument. That is a fait accompli. That is a foregone conclusion that yes, you are debating. But while you are debating, you must not lose sight of the practical side of argument. Accordingly, you may just fine-tune your arguments if you're prepared them in this manner. Then there's another part which I had noticed while because you're arguing a matter.
So you are not audible. So please turn on your mic.
So you're not audible right now.
Yes, my mic is functional.
Yes, my mic is functional. My mic is functional. My mic is functional.
There's some echo. Well, now I would rather now like to conclude this. Yeah, can you hear me, Dr. Singh?
Yeah.
Can you hear me now?
It's a great network issues.
Yes. Well, I think I should conclude my lecture now because there's a lot of echo.
Yes, it is. Yes.
Well, I'm so very grateful now. My concluding words. I wish all the best to the participating teams. I wish this moot court competition a great success. I shall be connected with you tomorrow also. I shall be available with you tomorrow. If need be, my telephone number can be shared. I'll request Dr. Neelam to share my number with whoever requires it. Even the participating teams, if they need any guidance from me in any manner, in any way, I'm available. I once again say thank you to Dr. Singh who invited me for this moot court competition. And I shall stay connected with you guys. Wish you all the best. Thank you so very much. I shall be taking your leave because I'm attending a court martial here, and the court martial adjourned for 1 hour for me. So I've just got a call from them that the court is again assembled and they're waiting for me. I'm representing an officer here as his lawyer, so I shall be getting back to my job.
For showing your blessings and your benign presence. Thank you, sir.
I'm just.
Yes, Soumya, please continue.
And regulate judgment awards. Semi-finals, finals. The preliminary rounds, each team is allowed 12 minutes to represent their cases. Each team shall represent from both the sides. The winner of each courtroom will be decided on the basis of the scores awarded by the judges in this round. The qualified teams after this round will proceed to the quarterfinals. The quarterfinals, the qualified teams from the preliminary rounds will qualify for the quarterfinals. The quarterfinals shall be a knockout round. The win-loss shall be decided on the basis of the aggregate speaker score. Each team will get 15 minutes for arguing. Please note the exchange of memorials will be only for semi-finals and final rounds. The semi-finals, the top 4 teams from the quarterfinals will qualify for the semi-finals. The side of the teams shall be decided by way of draw of lots. The semi-finals shall be a knockout round. Each team will get 15 minutes for arguing and 5 minutes for rebuttal. The finals, the top 2 teams selected after semi-finals will proceed to the finals. The side of the teams shall be decided by way of draw of lots. The win-loss shall be decided on the basis of the aggregate speaker score. Each team will get 25 minutes for arguing and 5 minutes for rebuttal. Please note, inside the courtroom, all the participants shall be in the formals. The awards and prizes. The following awards shall be awarded in the competition. Best team,
Due to shortage of the time, we are moving towards the drop lots. In courtroom 1, match 1 from 11:15 a.m. to 12 p.m. will be between team A15, B15 as appellant and team A18, B18 as respondent. Match 2 from 12:15 p.m. to 1 p.m. will be between team A7, B7 as appellant and team A3, B3 as respondent. In courtroom 2, match 1 from 11:15 a.m. to 12 p.m. will be between team A1, B1 as appellant and team A9, B9 as respondent. Match 2 from 12:15 p.m. to 1 p.m. team A6 as appellant and team B10 as respondent. Courtroom 3, 11:15 a.m. to 12 p.m. team A4 as appellant and team B13 as respondent. Match 2, 12:15 p.m. to 1 p.m. Appellant team will be team A4 and respondent team will be team B13. Courtroom 3, match 1 from 11:15 a.m. to 12 p.m. will be between team A4, B4 as appellant team and A13, D13 as respondent team. Match 2 from 12:15 p.m. to 1 p.m. will be between Team A17, B17 as appellant and Team A14, B14 as respondent. In courtroom 4, match 1 from 11:15 a.m. to 12 p.m. will be between Team A16, B16 as appellant and Team A12, B12 as respondent. Match 2 from 12:15 p.m. to 1 p.m. will be between Team A11, B11 as appellant and Team A5, B5 as respondent, Team A8, B8 as respondent. Link for joining the courtrooms will be shared with all the participants on the WhatsApp numbers as mentioned on the registration forms.
I would like to clarify that in courtroom number 1, from 11:15 a.m. to 12 p.m., Team A15, B15 will be joining as appellant and Team A8, B8 will be joining as respondent. I repeat, Team A15, B15 as appellant and Team A8, B8 as respondent in the courtroom number 1. And in courtroom number 4, from 12:15 p.m. to 1 p.m., Team A11, B11 will be joining as appellant and Team B50, A5, B5 as respondent.
Soumya, Professor, I figured the
Soumya.
I would like to how to present you
We can also
I request all the participants and judges to please open your cameras for the photography session. Thank you.
Students, please turn on your cameras quickly and then proceed towards your respective courtroom. Jaden sir, once the photo session will be over, please inform the students to proceed.
Thank you everyone for the cameras. Now all the teams can move towards the courtroom as assigned. And last,
Thank you, everyone. You may proceed to your courtrooms now. Student conveners will be sending you the links to your courtrooms. Please proceed to your courtrooms.